Good morning, ladies and gentlemen. I would like to welcome you at today's webinar. My name is Julia, and I will provide the technical support of the event today. Could you please write once again in the chat if you can see and hear me well? You can do this below in the chat. Okay, thank you for your feedback. Now I can see that everything is all right with sound and video. I would like to start the webinar then. Let me introduce our speakers today. Evgeny Alexandrov, Chief Lawyer, and Vladimir Trey, Partner and Trademark Attorney. Evgeny, Vladimir, you have the word.
Thank you, Julia. Good morning, ladies and gentlemen. In our today's webinar, we will touch upon the issues of trademark use, non-use cancellation proceedings, and recent changes in the Russian legislation in this regard. Let me introduce my colleague, Mr. Evgeny Alexandrov, Deputy Head of our legal department of Gorodissky and Partners, who will be speaking about procedural issues. My name is Vladimir Trey. I am a trademark attorney, and I will give you a short introduction on the Russian legislation in connection with proper use of trademarks. Our presentation will last about 40 minutes, and you will have an opportunity to pose your questions after the presentation has been completed. Please type your questions in advance so we could process them rapidly after we stop speaking and provide our responses. As you might be aware, since the beginning of December 2011, non-use actions come under the exclusive competence of commercial courts, courts of Moscow, rather than to the Chamber of Patent Disputes, which is a division of the Russian Patent and Trademark Office. And the decision to examine non-use issues in court may be regarded as a transitional measure on the way to creation of the IP court that will start operations in the next year, in particular in February 2013. Obviously, the examination of non-use issues in court will be more costly than proceedings before the patent office, and the procedural rules will be more complex. However, the court procedure should allow the plaintiff to recoup some of its expenditures from the losing party. So as the background for non-use cancellation procedure, we should mention Paris Convention. Its provisions were incorporated into Article 1486 of Part 4 of the Russian Civil Code. And this article, by implication, provides for mandatory use of a trademark as a condition of keeping the trademark holder's right for his trademark. According to the mentioned article, legal protection of a trademark may be terminated ahead of time in respect of all or a part of goods in connection with non-use of this trademark for 3 years period after the trademark registration date. And the condition for this should be that the trademark has not been used right up of the filing date of the non-use cancellation action. In the previous editions of the law, we had the 5-year period for non-use. Now we have the 3 years period in the Civil Code, and this 3 years period applies to all registrations, also to those which were registered under the previous edition of the law. And this position in respect of calculation of the vulnerability period was confirmed by the decisions of the Chamber of Patent Disputes as well as of the decisions of the court. It should be pointed out that the use of the trademark should be continuous, and constant use of the trademark without interruption is a condition to safeguard the trademark owner's rights from successful non-use action filed by third parties. According to the Civil Code, the burden of proof of trademark use lies with the owner of the challenged trademark. The party who files the cancellation action is not required to submit any additional materials proving non-use of the challenged trademark. In other words, the filing can be motivated by the third party's opinion that the trademark is not in use and documents showing the plaintiff's legal interests in canceling the trademark. According to the Civil Code, there are certain types of trademark use, namely the exclusive right to a trademark may be realized for the individualization of the goods, work, or services with respect to which the trademark is registered. The use may occur on goods or labels or packaging of these goods that are introduced into civil commerce on the territory of the Russian Federation. Further, a trademark may be used in performance of work or rendering of services. The trademark may be used in documentation connected with the introduction of goods into the market. A trademark may be used in proposals for sale of goods, for performance of work, and for rendering of services, and also in announcement on signs or in advertising. Trademark may also be used in the internet, including in a domain name or in other means of addressing. It is important to point out that the Civil Code identifies several parties which can properly use a trademark. So a trademark shall be considered as used if it is affixed to the goods by which for which it has been registered by the trademark holder or a person who has been granted such right based on a license contract. Thus, the trademark should be used by the trademark holder or his licensee. Or another option is to use the trademark under control. And this is a quite recent requirement of the Civil Code. And for the time being, I have to say that we do not have sufficient practice of proving use of trademarks under control of the trademark owner. But nonetheless, we had some cases where we managed to prove use under the trademark owner's control. As I mentioned before, and it is very important that the use may occur under a license agreement, and a license agreement should be obligatory recorded with the Russian Patent Office. This is a strict requirement of our legislation, and on the screen you can see an extract from the Civil Code which prescribes registration of any agreement which concerns trademark. This could be an assignment, and this also concerns licenses. So if a party is using a trademark under a license agreement, it should go to the patent office and record this agreement with the patent office. During consideration of non-use cancellation action, it is possible to point out that the trademark was not in use due to some excusable reasons. And these reasons have to be beyond the trademark owner's control. In this case, such reasons could be taken into consideration. But I have to mention that Part 4 of the Civil Code does not list the excusable reasons for non-use of a trademark. And in this instance, we have to refer to other provisions of the Civil Code, in particular to Article 401, which determines excusable reasons for some actions or non-actions. And this could be force of nature, disasters, military actions, personal health of a party, absence of raw materials, or some types of unexpected changes on the market. In our practice, we had some cases where we managed to argue successfully that the trademark was not used due to some excusable reasons. In particular, we managed to confirm that the trademark owner was unable to use the trademark due to the economical circumstances, in particular due to the economical crisis of the year 1998. But nonetheless, if we want to argue in such a way, we have to submit any evidence that the trademark owner had the intention to use the trademark, but was unable to do it, to use the trademark properly due to some economical circumstances. And anyway, it would be necessary to submit any advertising materials or preliminary contracts with third parties concluded between the trademark owner and third parties. As the burden of proof lies with the trademark owner, it is important to point out that the trademark owner should compile evidence of use right from the date of the trademark registration, as otherwise in 3 years the trademark might become vulnerable to non-use cancellation. These documents, if compiled from the registration date, may be effectively used in case of non-use cancellation proceedings, and the trademark owner should actively work with his Russian business partners to store the necessary documents in archives at the Russian business partners' end. Which evidence might be used in non-use cancellation proceedings? First of all, these are shipping and customs documents, some kind of financial documents such as invoices, copies of delivery agreements with indication of the trademark and the trademark owner. It would be great if goods are also mentioned in these agreements or in attachments to these agreements. The trademark owner could make use of copies of annual reports, some extracts indicating that Russia as the country of supplies could be supportive. Information about volume of sales could be also submitted in defense against a non-use cancellation action. What else could help? These are statements or evidence from local distributors of the trademark owner, or some evidence from local shops such as price lists. In defense of a trademark, we can make use of Russian quality certificates or conformance certificates. Copies of dated advertising materials in Russian language or dated extracts from the Russian magazines or newspapers or TV commercials could also be supportive. At that, I would like to mention that the legislation does not contain an exact list of materials which could be submitted in defense of a trademark against a non-use cancellation action, and it is up to the trademark owner to decide which documents he would like to submit in defense. But our practice shows that the more evidence we submit, the better chances to defend the trademark would be. Another implementation of the Paris Convention is the possibility of use of a changed trademark and use of a trademark with some changes which in some of the elements of the trademark that do not alter the distinctive character of the trademark shall be considered as use of the trademark. And use of such changed trademark does not lead to termination of legal protection and does not limit the protection granted to this trademark. On the screen you can see some examples of insignificant changes that should not lead to termination of legal protection of the trademark in case of non-use cancellation proceedings. But the question whether the difference and changes to the trademark, the changes between the registered trademark and the trademark in actual use are significant or not is up to the court to decide. And this is a decision of a particular judge which can have his own opinion on the significance of changes, and therefore, in order to avoid the subject of dispute in this connection, it is recommendable to use the trademark or registered, or another option is to register the trademark in all forms or in the most important versions in which the trademark is intended to be used in the future. Some issues in connection with non-use cancellation proceedings still remain undecided. And first of all, this is the amount of goods to be sold in order to be sufficient to prove the use of a challenged trademark registration. In our practice, we had several cases where we had to prove use of trademarks which were placed on products sold in Russia in some insignificant amount. For example, the use of a trademark on firelighters which were sold in Russia only occasionally was not considered to be proper use, and the trademark for these firelighters was cancelled. But if we have to prove the use of a trademark on some kind of luxury goods or, for example, on cars, then we can show only occasional use that occurred constantly. Another issue is whether use of a trademark on specific goods can be accepted into evidence of use of this trademark for the general term of mentioned in the class heading. For example, if we have to prove use of a trademark on some part of clothes, on shirts, on pants, and so on and so forth, and we have to prove the use of the trademark for general item clothes, then it should be all right. But if we, for example, speak about the class heading of class 9, and the trademark was used on such goods as safety products, safety gloves, and so on and so forth, then the use of the mark on these goods would not be sufficient to show the use of the trademark for the class heading. To sum up this part of the presentation, I would like to give some recommendation on the use of the trademark and on compiling evidence of use. So as I mentioned before, the use should be without significant changes, and the trademark should be used for all registered goods or services. Otherwise, the trademark will become vulnerable in respect of those goods for which the trademark was not in use. It is recommendable to compile evidence of trademark use right from the date of the trademark registration. What else is important to point out that the trademark owner should inform the Russian Patent Office about any changes of the trademark owner's address or name in a timely manner. This should allow the trademark owner to receive the court's notification or ruling regarding the filed non-use cancellation action, because such notification will be sent directly to the trademark owner. As it was mentioned, license agreement should be recorded with the trademark office. If the trademark use occurs under control of the trademark owner, then such control should be evidenced by any documents. And while filing the trademark applications, while drafting applications, the trademark owner or his attorney should list the list of goods very attentively, should draft the list of goods very attentively, and mention in the application not only the general items such as class headings, but also specific positions of goods of interest in addition to class heading or instead of it. This concludes the first part of our presentation, and I would like to ask Evgeny to take the lead and to speak about the important procedural aspects of non-use cancellation proceedings, bearing in mind the recent changes to the Russian legislation in this connection. Meanwhile, I would enjoy reading your question in the chat. Жень, говори погромче. Да, сейчас.
Do you hear me? Okay. Okay. As regards the court system, now it looks like the four instances system. The first instance court, Court of Appeals, Court of Cassation, and the supervisory instance, which is represented by the Supreme Arbitrazh Court, which is also called as a commercial court. And as of from December 2011, the system of the court has been changed, and a new court has been introduced as an intellectual rights court, which will be effective and will work from February of 2013. Before that date, the non-use cancellation actions will be handled by the Commercial Court of Moscow. And as from February, such kind of cases will be handled by the specialized court. According to the law, the intellectual rights court will handle such cases as concerning infringement of intellectual property rights as the cassation instance, while such cases will be handled by regional courts as a first and appeal instance. Also, this court will handle such cases which are connected with appealing decisions of the patent office and non-use cancellation actions. The specific thing of this court is that there should be a technical expert who will be in the staff of the court, and they will consult the judge during the hearing. And this court will be located in Skolkovo, which is an innovation center in Moscow region. As you can see on this slide, there is statistics of intellectual property cases handled by commercial courts, and you can see from the line regarding the trademarks, in 2011 there were 772 cases handled by commercial courts. And as we can see, from the December of 2011 until now, there are about 50 cases concerning non-use actions. And as we know, just one case came up to decision. On the basis of the decision of the court, the trademark may be cancelled due to its non-use with respect to all goods and services listed in the trademark certificate, or with respect to part of those goods and services. That the action can be filed by any interested party, and that there is no need to prove that the trademark is not in actual use. At the same time, it is sometimes advisable to conduct an investigation before filing a non-use action, just to be sure that the trademark is not in use. Otherwise, there would be risk that the claim will be rejected by the court, and the plaintiff will bear some costs connected with the consideration of the action with the court. Therefore, sometimes it's really advisable to conduct a preliminary investigation on the use of the trademark on the Russian market. Besides, before filing a lawsuit, it is necessary to collect evidence confirming the legitimate interest of the plaintiff. Otherwise, the court may reject the claims just on these formal grounds that the plaintiff hasn't proved the interest in termination of the trademark. It should be noted that no pretrial order is provided by the law, and the plaintiff, which is interested in termination of the trademark, can file a lawsuit in any stage. There is no need to send cease and desist letters or warning letters to the right holder. It is possible just to draw up a lawsuit with their arguments and claims and submit it with the court. at the moment of filing a lawsuit, the following documents must be submitted along with the lawsuit. First of all, this is a power of attorney, which must be duly notarized and legalized. It should be a document on the legal status of the plaintiff, which also must be duly notarized and apostilled, and of course evidence of the legitimate interest of the plaintiff, and these documents must be submitted in original or duly notarized and apostilled copy. The issue of the interest, how to prove the legitimate interest of the plaintiff, is not explicitly explained by the law, and therefore we can rely only on the practice. And a year ago there was a case handled by the Supreme Arbitrazh Court or Commercial Court regarding cancellation of the trademark. The court considered the case and elaborated very important criteria which may be used to determine whether or not the plaintiff can be considered as an interested party. The court said that any person can be recognized as an interested one if it has a legitimate interest in termination of the legal protection of a trademark. And such persons could be producers of similar goods, services with respect to which a non-use action was filed with the court, and persons who have actual intention to use the trademark and already performed necessary steps, for instance, filed a trademark application for an identical or similar trademark. And on the basis of this court practice and on the analysis of approach applied by the court, we may conclude that the persons may be recognized as interested if they are manufacturers of identical or similar goods, or they are owners of company names which are similar or identical to the registered trademark, or they are owners of the trademarks registered in other jurisdictions. And of course there should be entities which could produce sufficient evidence of real and good intention to use the trademark in Russia. So if we speak about documents, the plaintiff may provide the court with firms' brochures, company profiles, advertising materials, evidence that the plaintiff is the producer of similar goods, and copies duly certified and apostilled of trademark registrations in other countries. It should be noted there is no need to submit evidence specific to Russia. There is no need to provide the court with evidence that the plaintiff is already on the market. It's not necessary to provide documents on importation of the product or distribution of the products bearing the trademark in question. It's not necessary to provide advertising materials regarding Russia, because there is a high risk of being sued for a trademark infringement, because according to the Russian legislation, the trademark shall be cancelled for non-use from the date of the court decision enters into force. Until that date, the trademark shall be considered as valid, and therefore the trademark owner shall be entitled to enforce his trademark rights, even though the trademark has been cancelled due to its non-use. Litigation usually starts and always starts from filing a lawsuit. There is one thing that should be taken into account. Sometimes the Russian Trademark Office can cite different or several trademarks against a trademark application. And in case some of the cited trademarks or all of them belong to the same party, it is possible to file just one lawsuit in which we can cover all the cited trademarks. This shall allow to save the costs, and there will be no need to file separate actions with respect to each cited trademark. Along with the lawsuit and documents mentioned above, it's necessary to pay a state fee, which is not very high. It's $140, which is even less than it was before, when the cases were handled by the Chamber of Patent Disputes, where the official fee was $410. Upon receiving of the lawsuit, the court checks whether it meets the formal requirements, and if everything is okay, the court schedules the date of the preliminary hearing. A couple years ago, the Supreme Commercial Court supervised a very important project which is now effective. It is called electronic justice. This system allows to electronically file procedural documents with the courts. It is now possible to file the lawsuit, evidence, and different procedural documents such as motions, requests, and etc. electronically. There is no need to go to the court and submit documents directly. This system allows us to observe deadlines, even if the client instructs us to file a lawsuit exactly the day when the deadline expires. This system also allows to monitor the developments in the case and very quickly obtain information about developments and judicial acts issued by the courts. The hearings are divided for two stages: preliminary hearing and the hearing on the merits. At the preliminary hearing, the parties present their arguments, their position, their open evidence, and submit motions with the courts. For instance, if there is a need to order for an expertise, the parties may file a motion for the expertise. At this stage, the court may suggest the parties to solve the dispute amicably by way of entering into an amicable agreement. And this is a good option which could allow the parties to save the costs for the legal proceedings, and if they in principle could agree for settlement of the disputes in some way, they may conclude an amicable agreement. And this agreement must be approved by the court and will be effective as from the date of approval by the court. At the end of the preliminary hearing, the court schedules the date of the main hearing. Some clients ask if injunctions are available in Russia. Indeed, the Russian procedural legislation provides for preliminary and interim injunctions. And specifically to non-use cancellation actions, we believe that such injunctions can be used to prevent assignment of the trademark in question until the decision on the case is issued. If we imagine a situation when there is a pending trial during which the defendant assigns the trademark to another person, and if the court issues a decision to cancel the trademark, a new trademark owner may appeal the decision, and that will be absolute ground for cancellation of the decision of the first instance court, because the right holder at the date of the decision was issued wasn't involved into the case. At the main hearing, the parties provide the court with their positions, their arguments. They provide the court with additional evidence if they collected them before the hearing on the merits. And then the court examines those evidence. In case the court has some questions to the parties, the court can ask them. And if everything is clear for the judge retires to the decision room. And the decision is announced at the same hearing. As regards the evidence and documents submitted with the court, it should be noted that all the documents executed on the territory of a foreign state must comply with the procedural requirements of the Russian legislation. That means that the documents evidence of use of the trademark or evidence of the legal interest of the plaintiff, they must be submitted in originals or as a duly certified copies, and that legalization of these documents is required. Besides, the documents in foreign language must be translated into Russia by a certified translator, and the translation must be also certified by Notary Public. But we must say that it doesn't cost many expenses to the clients. This procedure is really not very complicated. The decision of the first instance court comes into legal force after expiration of 1 month from the day of the decision made in the final form. It means that from the day when the decision is issued in full text, and if no appeal filed with the Court of Appeals within this term. The Court of Appeals has the power to dismiss the appeal or change the decision of the first instance court or issue even a new decision. At that, the resolution of the Court of Appeals enters into legal force from the date of its adoption. Then the decision of the Court of Appeals may be appealed to the next court instance, which is called Cassation instance or Court of Cassation, within 2 months from the date when the decision of the Court of Appeals was adopted in a final form. The Cassation instance checks whether or not the courts of lower instances correctly use procedural rules and other rules of legislation of the Russian Federation, and it has the power to dismiss the appeal or leave one of the previous judicial acts in force, or change the decision, or issue a new decision, or send back a case to the first instance or appeal instance. And the last court instance is a supervisory instance. It's the Supreme Arbitrazh Court. And the decision of the Court of Cassation may be appealed to the Supreme Arbitrazh Court within 3 months from the day of entry into legal force of the last judicial act passed on the given case. This court, besides this court can leave judicial acts in force, or can amend judicial acts, or can issue a new one. This court is very important because sometimes it issues decisions which can be considered as precedent one, because of course there is no precedent or case law in Russia, but the positions elaborated by the Supreme Commercial Court are usually used by the parties and by even the courts, lower courts, and therefore positions elaborated by the Supreme Commercial Court have great impact on the whole practice for the intellectual property. As regards the legal costs, they composed of state fee, attorney fee, and other expenses connected with the trial. According to the law, all legal costs shall be recoverable from the defeated party within reasonable limits. Unfortunately, the law doesn't provide explanation on what those reasonable limits are, and that means that the court is free to determine which amount of legal costs can be awarded to the winning party. And about 1 month ago, there was a case handled by the Supreme Commercial Court, where the court confirmed the right of the plaintiff to claim the full amount of legal costs spent for the trial, and the attorney fee in that case was $100,000. And as the last part of our presentation, we would like to present you the first decision on the non-use case, which has recently become available to us. The decision was issued on April 13, And according to this decision, the court decided to cancel the trademark due to its non-use and obliged the trademark office to record the changes in the status of the trademark in the trademark registry within 10 days. And also the court ruled to recover legal costs of state fee from the defendant. So we have just now one decision regarding the non-use actions, but we do believe that the practice which was formed by the Chamber of Patent Disputes can be also applicable to the cases which are now handled by commercial courts. This is the end of our presentation, and thank you very much for your kind attention. And please, if you have questions regarding the issues we mentioned in the presentation, please, you can ask us now.
For the time being, we have one question. It is posed by Ann Hawking. It's Ann Hawking, and she asked when it is preferable to file a non-use versus cancellation action. In the US, non-use is determined in cancellation actions, so I'm not sure of the difference. If I understand your question correctly, I would respond that non-use cancellation proceedings and cancellation action against the trademark registration are separate, different proceedings in Russia. And in order to file a cancellation action, for example, based on prior rights, you have to go to the Chamber of Patent Disputes of the Russian Patent Office. If you file non-use cancellation action, now you have to go to the court, and these proceedings would be considered separately, and now actually these proceedings are considered in by different bodies. But if a cancellation action and, for example, an invalidation action against the trademark registration is filed, the trademark owner of the challenged trademark has an opportunity to go to the court and file a non-use action against the registration on which the invalidation action was based. But it would not be possible to suspend the invalidation proceedings before the Chamber of Patent Disputes based on the pending action at the court. I hope I responded to your question. Further questions are welcome.
Yes, we have some time for questions. You can also ask questions not only regarding the non-use, maybe you have questions regarding general trademark or law issues. While we are waiting for the questions, if we are not ready to ask us now, you can join us at the Inter in Washington. We'll be there, and we can meet up at this event and discuss some questions if you have.
Yes, we have another question. Any information on how is the IP court formed?
The court, now the structure of the court is the following. There would be about 35 judges, and preferably with a technical background, and there will be technical experts in the staff of the court, and the court will consider the cases at the first instance, the cases against the patent office. And if the court issues a decision at the first instance court, then the court considers such decisions as the cassation instance. That means that no appeal instance exists in the court. If the court considers the issues regarding appealing of decisions of the patent office, these issues are considered at the first instance court. However, if we speak about infringement actions, the intellectual property court will consider such cases as the cassation instance. So the first instance and appeal instance will be in regions, and no judges which are required to have a special background in the intellectual property field will consider these cases. But this is I believe that this court will elaborate some practice which shall allow the courts in different regions to use the unified practice established by this court.
So we had another question about the interparty. So please send me an email. I will revert with the invitation and contact details. The party will be in Grand Hyatt. As far as I remember, it will be held on Sunday in the evening, so at 8 probably. But I will send out our invitation to you once again if we haven't done it yet.
We have now a question regarding the interest, and the question is, you mentioned that anyone can file a cancellation action and the interpretation of the interest is pretty broad. Is it possible to request the court any damages for parties to initiate actions without real basis thought? Indeed, interpretation is not actually provided by the law, and therefore we may judge about criteria of the interest on the basis of court practice. However, the court examines the real interest of the person. The court checks whether or not the person has a real intention in use of the trademark. For instance, if the person just wants to cancel the trademark, but doesn't show that the person has a intention to use the trademark, didn't file even an application for registration of the trademark, of course the court will dismiss the case. And as regards damages for the parties, according to the law, the damages and compensation may be claimed in favor of the winning party. Therefore, if the court satisfies the lawsuit and cancels the trademark due to its non-use, the plaintiff may count on compensation of legal costs. But if the plaintiff loses the case and the defendant confirms and proves the use of the trademark, the court, of course, will award compensation in favor of the defendant.
So another question is mostly personal question regarding publication. So yes, of course, we would be pleased to write an article like we do for other editions, and it would be a pleasure and great honor for us to write an article on non-use issue in the INTA bulletin.
There is a good question regarding the legal fees, and The question is that is there any benefit to affirmatively and use trademark registration rather than allowing the litigation to move forward? Is the owner still susceptible to having to pay the legal fees? There is clarification to the issue concerns whether or not, as far as I understand, whether or not it is sometimes wise to abandon the trademark registration then move forward with the litigation. Indeed, the fee for filing a request with the patent office for abandonment of the trademark is much cheaper than legal costs, and in case litigation has been started by a third party, the trademark owner may anytime apply with the trademark office and abandon his trademark. In this case, we believe that there will not be a good ground for the plaintiff to claim any damages or legal costs or compensation, because there will be no subject for consideration by the court. It could be a good opportunity to save the costs if the trademark owner is not interested in the trademark.
So you can use the address. I'm responding to Maxim's question regarding the contract's email. So you can use the address which is now on the screen. So it's pat@gorodissky.ru. So then it will be forwarded to me, and so we will get in touch.
Welcome.
So another good question is whether an application for the marks subject to cancellation by the plaintiff suffices to as that third party's interest based on your experience. So actually, the fact of simple filing a trademark application is unlikely to be considered sufficient to prove legal interests of the plaintiff. This is confirmed by the existing practice in this regard. So the plaintiff should have a real intention to use a similar or identical trademark.
Yeah. For instance, you cannot claim that you have legal interest while you just filed an application for all 45 classes of international classification. Obviously, you are not producer of all the goods and services. Therefore, the court will not recognize, most likely, such person as an interested one. Therefore, besides producing a copy of the trademark application, it's advisable to produce other evidence, such as even printouts from the official website of the claimant, confirming that the claimant deals with the particular goods which are listed in the trademark registration and with respect to which the cancellation action has been filed.
Another question, what happens if you do not record a license agreement with the Russian Patent Office?
If the license agreement is not registered with the patent office, it is considered invalid and void. And the parties cannot rely on this agreement except the cases concerning the non-use, because according to the provisions of the law, as Vladimir said in his presentation, his part of presentation, that the trademark may be considered as used if it was used by the third party under the trademark owner's control. That means if the party provides with the unregistered copy of the license agreement, it could be considered as the use of the trademark under the trademark owner's control. But this agreement will not have effect of a license one. From the point of view of the law, it will not be considered as the license agreement which is effective under the Russian law. It could be used only as evidence of use of the trademark under the control of the right holder. So, I think if there are no more questions, we can finish our today webinar. And thank you all for attending our webinar, and we hope that we will continue our webinars. And if you have ideas or you have some questions which are interesting for you, please send to our email so that we could include them into our presentations and discuss them with you.
Thank you very much for your attention, and for to all of you for attending this webinar. It is very important for us that it was of interest and it was well attended. We will see some of you certainly during the approaching INTA conference, and we hope that you will attend our future presentations.
Oh, thank you, and have a nice day.